Hi, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're continuing our video series designed to educate and inform the public. So please subscribe to our channel. You know, the court is very, very encouraging of the parties getting together and trying to work things out. The court always believes that within a marriage or the dissolution of a marriage, it's better for the parties, even begrudgingly, to sit and work things out than to have the court say, you shall do this, you shall do that. And why? Because the court only has a very much a bird's eye view of what's going on in your life. The parties are in better position to know what's going on in their lives. So when the parties get together and say, Your Honor, we've worked this out, I'm going to pay her $500 a month as alimony, the court, of course, can take a position, can make you explain it, can double check, run guidelines and stuff like that, but generally speaking, if you come with something that's fair, that makes sense for you, that the recipient says, it's okay, Your Honor, because while he may make more money, I'm getting this concession instead of that, or I happen to know that it's not always reliable, that usually he makes less, whatever, the court will, in a situation like that, yield to your expertise within the relationship. Now, so therefore, if alimony is an issue, should the parties agree on it? I think the parties should make every effort to try and agree on a number. Remember, alimony is a form of support, but it's not the same as child support from the standpoint that we have child support guidelines. We have mandatory guidelines. You've got to establish a record to deviate from those guidelines. There are alimony guidelines too, but they're not as controlling. They're more suggestive. There's a totality of circumstances that goes along with alimony. So I think if the parties can agree on a number that makes sense for everybody, where the payor can say, okay, I think I can agree on this and I think I can live up to it. And the one who's receiving it will say, okay, I think that's a fair number and I can make that work. The court will very much likely embrace that notion and support that settlement. It is possible, like I said, that the court might make inquiry about it, but generally speaking, the answer is the parties should try to amicably work out things like alimony payments so that they're not pressed into the decision that the court makes, which they may or may not like down the road. If you have any questions about your case, reach out and we'll be glad to help you out.